Show are those of the show personalities and guest alone, and not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening, South Florida. Welcome to another Ask the Experts, where we bring you some of the top experts in legal, health, financial, and home improvement. And this is, you wrote me, I probably got at least 50 emails from listeners who said, why aren't you doing more shows with Kay Bender-Rimbaum, the Community Association Law Show? We just didn't have the room, but I guess about 2 months ago, we opened up a space because you've asked for it, and now we do the Kay Bender-Rimbaum Show on Ask the Experts the first Thursday of the month and the last Thursday of the month. Our guest tonight from Kay Bender-Rimbaum is a name that I have heard. Kay Bender-Rimbaum has been with us for 5 years. Excuse me. There's a name of one of their great attorneys that I've heard for years, and I finally get to have her on our show. Let me introduce you to board-certified attorney Lisa McGill. Hi, Lisa.
Hi.
I've heard so much about you, and I can't believe we've never had you on the show before, but I'm sure glad we have you now.
I'm glad to participate on the final, the last Thursday of the month, and we'll hope to do so periodically going forward.
I love that. I just, people call up. You saw today I sent you the questions. This show is without a doubt not only my hottest show in South Florida, but between all the other 8 cities we're in. So we're glad that we could make room for Kay Bender the last Thursday of the month now. And what we do is we take your questions throughout the month, and we actually read your questions on our show. And before we get started, Lisa, tell everybody about yourself.
Well, I'm happy to be here. My first time participating. I have been with the firm for about 5 years. I've been practicing in this field for longer than I'd like to mention, but not only am I board certified in condominium and planned unit development law by the Florida Bar, I'm also a fellow of the College of Community Association Lawyers, which is a national accreditation. So my entire practice has been devoted to community association representation, and I'm happy to participate today.
Well, I got to tell you that people who live in condos now are a little concerned. I know I heard the new ratings come out for the insurance companies, and it looks like we might be losing some more insurance companies. And when that happens, rates seem to go up, which has nothing to do with you at all. And the new law now about the 3 stories or higher after 30 years, that's not going to be cheap, and those reserves are going to have to be fulfilled. Is that right?
Well, I'm thinking, and I'm planning to see some adjustments in the law, so there may be some tweaks to ease the burden on community associations, but this is really long. This is really long overdue. It's hard to impose as an after effect, but it really would have been something that should have been in place for a very long time, so we don't have the distressed properties that we're seeing right now. Unfortunately, for the properties that have failed to plan, that is a plan to fail. So there should be adjustments in the law to create a far larger ramp up time to let people get into funding reserves on a lower level and then a medium level and then hopefully on a higher level. But I can tell you that the requirement to have a formal formal reserve study and a formal engineering inspection really is so necessary, because we do see properties that have failed to maintain in an appropriate way, and by doing patch fixes or less than stellar repairs, it's actually increased exponentially the cost for the repairs when they no longer can be prolonged. So yes, there are growing pains. There are always growing pains when it comes to making changes, but hopefully in the long run, we'll see a far better and a far more stable condominium and high-rise type community.
Lisa, where are they going to get all these engineers to do all this
That's
work?
another issue. You know what?
Yeah.
If you have a child in the teenage and they're good at math, send them to engineering school, because we need them.
Yes.
And University of Florida has a great engineering school.
Okay, got that plug in. So you know what? We've already got our first phone call. Let's go to Becky in Palm Beach County. Good evening, Becky.
Hello, good evening.
Good evening.
Thanks for taking my call. And it's two-pronged. The first one I want to ask was, if you have an application process, our property manager says they can charge a criminal background check fee, and the amount is the amount allowable by law, but I didn't see anything in the Florida statute for homeowner association, Chapter 720, that states what amount is allowable by the statute. And then the second question is a bit different. It's for someone who's pro se and has a claim for damages against the HOA, and the insurance company, the attorney for the insurance company originally replied, but now there's a second attorney firm replying to the claim or complaint. And how would you establish what exactly each law firm is responding to, or which insurance firm they're representing? What's the easiest way to find that out, I guess?
Okay, well, let me take the second question first, because it's more fresh in my mind. So you have a claim against the association, and the insurance company is handling it on their behalf. You didn't say whether or not it's in litigation. If it was in litigation, then you would have the docket or a pathway to the docket through the internet, and you can see who's acting as counsel of record. If the claim is not in litigation, simply just ask. I mean, the insurance company will not have more attorneys than are necessary to reply on behalf of its client, its insured, the association. So there's no harm in you saying, hey, who am I supposed to be dealing with here? I really want to get my claim resolved. And then also you should be aware of who the internal adjuster is, or the claims examiner, so that you have a contact with the insurance company itself. Going to your first question, the HOA Act actually does not specify how much the association can charge. I know that sounds odd to you, because in the condo it's been $100 per person, and husband and wife and parent dependent child being considered one person for so long. It finally was increased to $150, and that is the limit that condo and cooperative associations are constrained with. But HOAs, obviously, you have to be reasonable. The screening fee or the background investigation fee is not a profit center. It's really to reimburse you for whatever costs the HOA incurs in connection with the transfer approval process.
Does that answer your question,
Right.
Becky?
Yeah. Yes, thank you very much. I just the one little thing you said about establish who the internal adjuster is a claims adjuster.
Right.
for the insurance company?
The claim with the insurance company, if it's not in litigation, there should be an adjuster or someone that you were dealing with before an attorney was involved. So that person should still be responsible for the file. And if you have that contact information, you can always reach out to them and say, hey, I'm getting, phone calls or emails or letters from various attorneys. I don't know who I should be dealing with, who's got the authority on behalf of the carrier.
Right. Thank you very much. Great.
Thanks,
stuff.
Becky.
Thank
You're
you.
welcome. Thank
We
you
have
for
a
calling.
line open at 888-565-1470. That's 888-565-1470. If you've got a HOA or condo question, we've got one of the finest attorneys in Florida, board certified, whose head's going to get really big after this show, board certified attorney Lisa McGill. Lisa, another question that we got a lot of is people seem to worry about this funding the reserve fund. Got a lot of people asking about this. And I got to tell you something. Two of the people that wrote us had relatives at, was it Champaign? Was that the name of the, in Surfside?
Champlain Towers.
Yes.
Yeah, Champlain Towers.
They had relatives there, and they were told, and it must be right because they both gave me the same number, that they needed $15 million in their reserve, and they didn't have it. The people who lived there didn't have it. So what happens in that case?
Well, first I want to allay everyone's fears. I mean, Champlain Towers,
Good.
that was an anomaly. I mean, people are talking about all different types of causes that contributed to the actual destruction of the building. So, if you feel, and if you're a community leader, particularly if you feel that there is some maintenance needs that need to be addressed, definitely hire the right professionals to come out to perform the inspection, to give you the repair specifications, identify what needs to be repaired, or give you the peace of mind to say, hey, your building is structurally sound, here's what I recommend for the next 5 years. So I don't want people to feel like,
I'm glad you
if they
said that.
see, some defects or deficiencies that, they're not safe in their own buildings. But that's a huge issue. I mean, funding is a huge issue. Now, this particular building was not a low income or low cost type property. I mean, these
Right.
units, there were several units in the building that sold for millions of dollars, and the assessment fees were high. The owners chose not to fund reserves. The board, there was a board there, and the board kept on getting turned over. We hear all kinds of nasty stories in the newspapers, but the board had made arrangements for financing for the repairs. So once they had decided on, what contractors or what engineers to use and got all the specifications, they would have been in a position to finance them through a lender. There are several lenders out here in South Florida area or the Florida area altogether that concentrate in community association lending. So I would encourage you, if you're a community leader, to ask around and see whether there are lenders that would be willing to give you a loan so that you can extend out those payments. But I have to tell you, 15 million is not the highest number that I've heard. And it really depends on what maintenance has been, what proactive maintenance, restorative maintenance has been performed on an annual basis. If you keep up with what is going on with your building, you won't have a $15 million bill. Now, some properties, the roof by itself could be close to $1 million. And that's one of the reasons why it's so important to have that reserve study. So not only the community leaders, the board members, or maybe the manager understand what expenses are coming down the pike, but all of the unit owners need to know what they are going to be required to fund and when those expenses are coming up. That may give people more incentive to fund reserves so they don't have to shell out thousands, tens of thousands of dollars in special assessment fees, or take a 20-year loan when they already have, their 30 or 20 years left on their mortgage. But there are various lending options available to associations. I can also say, and I don't know if I'm extending this too long, there are 2 federal proposals that are designed. They're only filed on the House side at this point. They were both sponsored by Senator Kristen and Representative Debbie Wasserman Schultz here in Florida. guess why? I mean, we have the people that have the substantial casualty that occurred. And they're designed, one of them is designed to provide relief to individual owners when the association levies an enormous assessment and they don't have the means to pay. So there are means testing in that particular program. And another is called this securing or rapid financing for critical repairs. And again, it's in the very, very infantile stages of the legislation. But if that actually comes to fruition, it will give community associations access to FHA rehabilitation loans in addition to all the private lenders that are out there.
If you'd like to ask Attorney Lisa McGill a question, you can call us here. Our show is live at 888-565-1470. That's 888-565-1470. Attorney McGill is with K. Bender Rimbaum. If you have a question, give us a call now. We have a note from Ken in Coconut Creek. Says our board is considering changing the canopy to a different color. Is that considered a material change, or should we take that to a vote?
It depends on whether you're in an HOA or in a condo. Condo law says that if you want to make a material alteration or substantial addition to the condominium property, you must obtain the approval of 75% of the members unless your documents say otherwise. So the particular condominium documents may allow the board of directors to spend a certain amount of money for what would be considered alterations or improvements without an owner vote. But alteration and improvement, in my mind, was never designed to be as simple as changing the color of a canopy. That being said, a lot of the cases that have gone through the DBPR's arbitration program have found minutia to constitute material alterations. So if you're in a condo and the condo documents don't say otherwise or don't allow the board to make material alterations, that's something you definitely want to address with counsel, because you may be required to take a vote in order to change that canopy, as trivial as it sounds.
Okay. 888-565-1470. We're talking about community association law tonight. Your condo association or HOA. Give us a call here at 888-565-1470. Julie in Hollywood said, we have a board of 7, and one of the members chooses not to be at any of the meetings. Can we get rid of that board member who refuses to come to the meetings, or do we have to wait for the elections?
There's really only 2 or 3 ways to get rid of existing board members. One is through the recall process, and that would require a majority of the entire membership of the community to either vote to recall that director or sign a written petition to recall that director. And of course, that's a huge effort on the part of the people that would like to find somebody else that's new for that position. Another method of changing directors or eliminating directors is if the director becomes delinquent more than 90 days in the payment of community association assessments. If the director is up to date on their assessments, that's not going to be an avenue for you. Or to ask the director to voluntarily resign. If they refuse to come to meetings and they don't want to participate, what would make you think that they even care that they're still on this board? Maybe they'd be happy to let somebody who's far more interested participate.
Lisa, do you think, I'm asking for your personal thoughts now, do you think the associations could find even better board members if they got paid?
That proposal's been kicked around, and it's especially true when you have what are considered non-residential condos, where you have a condo where everybody lives somewhere else, and maybe they're there for 2 weekends, every 3 months. Or what if it's a property like a hotel type condo where nobody really lives there? The properties are rented on a transient basis. I don't see that really happening anytime soon. But you're not precluded in the HOA context or in the condo context from changing your documents to allow for salaries for directors and then hiring people to serve as those directors. Most people, when they buy into a condo or an HOA, they really want to control their own destiny. I mean, this is their property, this is their community, this is where they live. They care about it, and they want to make it a nice place to live, a safe place to live, and a great, place to be with your friends and your family. But that being said, if you don't have people that are willing to volunteer, or you have volunteers that are just woefully inadequate, then then you can consider whether amending your documents to allow uh, salaries or compensation for directors is appropriate.
Here's Buck in Deerfield. Been a long time listener. He said, our HOA hired a new sprinkler system company, and the guy who comes out has an ankle bracelet. No, I'm just kidding. I'm kidding about that. No, it says, our HOA hired a new sprinkler system company, and he is not licensed. Can we get rid of him?
Well, if the company is performing services that are required to be performed by a licensee, I mean, one way to eliminate the service would be to file a complaint with the appropriate authorities, because the authorities would simply say, hey, you can no longer provide the service. I don't know if that actually gets you out of your contractual obligations, because you have to look at the contract. Does the contract say they need to be licensed? I know that sounds like something that shouldn't have been overlooked, especially when the job requires a license. But we see it all far too often, where people are contracted to perform services and they're not really even licensed, or they provide a license number for a friend or a buddy. So it's important for boards to check out who they're contracting with. It may just be that this person, the license may be expired, or they may only have a local license. From what I understand about irrigation, I think if you have a state license, you may be exempt from the local licenses. But again, I'm not 100% sure. That being said, you have a contract, and the contract says, I'm going to pay you, you're going to do this. And if the contract doesn't have any contingencies saying you have to be licensed to do this, well, I wouldn't say that you're automatically entitled to dump them and go to the next company.
We're going to go to break right now, and if you're on hold, we're going to get right to you as soon as we come back. Lisa, can you give us your phone number? Not your home number, but your office number.
Okay, Bender Rambam, we actually have 3 different offices. I'm in the Pompano Beach office. Our phone number is 954-928-0680. That's 954-928-0680. And we serve all of Florida. So if you're in Sarasota, or you're in Indian River or something, if we'll direct you to the closest office to handle your needs.
If you have a question, HOA or condo association question, we have one of the finest attorneys, and I can say that because she's certified, and the state bar allows me to do that. We're going to be right back with more. Kay Bender Rimbaum, Lisa McGill. We'll be right back.
Kay Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kay Bender Rembam attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kay Bender Rembam is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kay Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com, or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert show. This is our going on seventh year on 1470 AM, 96.9 FM, 95.3 FM, and iHeart Radio. We're here tonight. We've added this as a last show of each month, Kay Bender Rimbaum, and they have been with us for 5 years now. And we finally got the famous Lisa McGill. Lisa, I keep hearing your name for the last 5 years.
I don't know if I'd say that. I don't know.
Anyway,
if I would agree
you're
with
very
that.
well loved there. Trust me.
Okay, well, I hope so.
And
my mom's
we're
watching
gonna
too.
we're gonna. If you have a question for Lisa, boy, this is the time to do it. We've got 30 minutes left in the show. We're going to go to our phones. We're going to go to Jack in Boynton. Good evening, Jack.
Hey there, guys. Hi, Lisa. Good evening. It's curious. I'm in a condo. My friend is in an HOA. So this question, if you could answer for each one, I'd appreciate. Are there laws for American flags being permitted to be hung off of our units on during holiday times? Now, I know in my condo there are specific things in our docks that we cannot hang flags, but I was wondering if the U.S. flag could be hung on Independence Day or Flag Day or things of that sort. I'll hang up and I'll listen.
Thanks, Jack.
Oh, yeah, well, thank you so much, Jack. You know, we're a pretty patriotic state here. So both the HOA statutes and the condo statutes allow homeowners to display the American flag anytime throughout the year, so long as it's displayed in a respectful way, and so long as the owner is in compliance with other requirements. So you can't obviously make penetrations in the exterior of the building in order to secure your flag or what have you. The flag can be up to 4.5 feet by 6 feet, so it's a rather large flag. Now, in an HOA context, you're allowed to also fly the other government flags, the United States Army, Navy, Air Force, that kind of stuff, or the POW flags, pretty much any time of the year, so long as it's displayed in a respectful way, so long as it doesn't exceed the size limitations, and so long as you're inclined to other requirements. In a condo, on the holidays, you're allowed to not only fly your U.S. flag, but you can also fly one of those armed services flags on Memorial Day, Flag Day, of course, Independence Day, Veterans Day. There may be some other holidays that are implied. And what I remember, but I didn't see it, is that there may be an amendment that allows you to fly the Space Force flag. So we'll look for that. And I haven't really seen any Space Force flags, but maybe we'll see them. Maybe they'll become popular.
Thanks, Jack. If we have a line open now at 888-565-1470, 888-565-1470. Denny in Palm Beach asked, we had a former board president that paid himself $70 for time spent on deposition. What course of action can we take? He's the board president now. He wants to know what action he can take from a past president board member.
I can tell you, I understand being upset by that. I mean, why would somebody pay themselves? And who gave them the authority to pay themselves anything for anything having to do, or any work associated with being on the board? You're a volunteer. You're expected to perform those services as a volunteer. But I can tell you that $70, it's really not going to be worth your time or effort to make yourself aggravated in imposing some kind of fine or some kind of penalty or trying to get that money back. What I would suggest is that now you're the board president and you have other like-minded board members, adopt a policy that discusses or addresses when reimbursements will be permitted, and that likewise so absolutely prohibits payments for, quote, work type services, so that you'd spell out when the association is actually legally authorized to give a board member money, what kind of documentation would they have to produce in order to obtain a reimbursement, what type of advance authorization they would need in order to obtain a reimbursement. I mean, you can have a board member drive to Tallahassee because they feel like they want to do something with respect to a condo bill. Well, you're not legally obligated to reimburse for that expense. Again, that expense would need to be approved in advance by the board of directors. So this is something that I would ask you to address prospectively, and don't get all hung up about what happened with the $70.
I totally agree with you. Marvin in Boca, is it considered negligence if a board doesn't get leaking pipes taken care of and we eventually get flooding? Is it hard to prove negligence? And can you explain HO6 policy?
Okay, well, you have a whole lot of things going on there, but this is a very frequent problem, as you may imagine. First, you need to determine who's responsible, like what kind of pipes are leaking, where are they leaking from, whether the association or individual unit owners are responsible for the repair of those pipes. But if something is the association's responsibility and they've been notified of a problem and refuse to take care of the problem over an extended period of time, well, then yes, they could be considered negligent. In fact, they'd be likely considered negligent. And then if you suffer damages to the interior unit as a result, you're more than likely entitled to be reimbursed for any costs that you sustain as a result. The HO6 policy bridges a gap for you, though, because on a liability claim, when this would be a liability type claim against the association, you can recover damages for any of the personal property or portions of the unit that were damaged as a result of the negligent acts or the negligent omissions. But if you have the HO6 insurance, your own insurance policy will pay for your floor, damages to your flooring, damages to your countertops, damages to your cabinets, all kinds of damages, so that you will then have immediate repairs to take care of some of the issues that you want to address right away. And in the event the association is ultimately held liable, well, your insurance company will probably seek reimbursement from them for what it paid, but that doesn't reduce what you're entitled to for the other portions of the property that were not insured. So I always recommend, I'm the kind of person, I'm a conservative person. I couldn't live without insurance, regardless of whether or not I have a mortgage. And it's very, very important to have the insurance, not only for your own interior portion of the unit and your own personal property, but think about your liability. What if somebody slips and falls inside your apartment, or other types of liability claims? So I can't recommend having insurance more. I mean, really, I think it's a really very, very important tool. And if everybody is insured, if all the unit owners are insured and the association is insured, well, then if there's a loss, both sides of the property are going to be covered somehow. The association's policy is going to cover the portions of the property for which it bears responsibility, and your policy is going to cover your items. So having everybody fully insured just makes life a whole lot easier in a condo association.
Lisa, because I just from everything I've heard about you, I'm going to ask you this question. We had a person who's getting ready to run for board president, and he explained, and I hope I get the terminology and everything right, but he has a property that he has owned for 30 years. And a next door neighbor moved in and thought that he owned part of that property. Where he got that from, I don't know. And instead of trying to work it out or even going to court over it, he just dug up almost the whole entire property line, which had bushes there. Is he allowed to do that?
That's a big, big no-no, okay? First, you'd have to confirm where the property lines actually lie. And if there are existing improvements there, like a fence that was already permitted or landscape improvements that were there, I mean, again, even if it is your property, like say for some reason the surveys were wrong or the contractor that installed the fence, made a mistake and put it 1 foot over, well, that doesn't mean that you're absolved from liability from destroying somebody else's property. You destroyed their landscaping, you destroyed their fencing. I mean, you can't expect not to suffer any consequences for that. Mistakes happen, and I have a lot of these boundary disputes from time to time. They're not pretty. They definitely are not pretty, and obviously you'd have to open up the lines of communications between the adjacent property owners, do some research, get somebody else involved, and then at the end, maybe you can come to some kind of happy medium, because that's always going to make it more bearable for you to live there for as long as you want to live there in peace and in harmony with everybody else.
I remember he did tell me that nothing had been added in those 30 years, but he did say there might have been a mistake done 30 years ago. So could he lose part of his property after being there for 30
You mean
years?
the new owner that thinks the property is usurped? I mean, there are various legal theories for, implied easements or adverse possession or and the like. But again, those require very specific factual analysis. If this type of situation arises in a community association, I actually have one right now. It's a single lot line. It's a 0 lot line property where there's an easement and part of the neighbor's yard is actually encompassed within a fence line for the adjacent owner. And that's the way that the documents were set up. Well, somebody moved in. They're very, very upset that they, quote, lost a foot of their property, but that's the way the documents were set up. So you always have to take a look at the documents. You have to take a look at the specific facts and circumstances. I mean, you have to look at the length of time and what have you. And with respect to these boundary disputes, I mean, they can be very complicated, they can be very complex, and they can, if litigated, can take years to resolve.
Wow. So if a
And
person's been
that's an
there
expense.
if the owner has been there for 30 years, does that play into it also?
Certainly, with certain types of claims, yes, the duration of ownership and the duration of use without objection can definitely come into play, but it also depends on who was next door to them before that. Was the property occupied? Was it not occupied? Again, there are a lot of different facts that you'd have to take into consideration to determine whether any of these causes of action are even applicable.
Let's go to our last break. Lisa, give everybody the phone number at K. Bender Rembam.
Okay. Well, again, there is the Pompano Beach phone number is 954 928-0680. We also have an 800 number that will connect you to all of our offices.
Tampa,
I would
Palm
encourage you to
Beach.
go to www.kbrlegal.com, and you can get information about all of our attorneys and all of our offices and get all of our contact information, along with a lot of educational information, seminars, videos, including Ask the Experts.
Thank you. We're going to go to break. We'll be right back with more. K. Bender Rembam, attorney, board certified attorney, Lisa McGill.
K. Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembam attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembam is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This is the Ask the Expert show. I am Steve-O, your host. We have now the last Thursday of the month from 6 to 7, our friends at K. Bender Rembam. And we still are maintaining our first Thursday of the month also. We have board certified Lisa McGill, and I have heard Lisa's name ever since we started the show. So I guess Lisa is well admired and well liked at these beautiful offices in Pompano Beach. And they're big, and they love customer service there. Trust me. Lisa, I have more questions here from listeners, and I want to make, because we only have about 10 minutes left. Ken in Palm Beach Gardens has a question about line of credit. He wants to know, do we have to have 75% vote for a line of credit?
That also depends. That's a loan or incurring indebtedness that I talked about before, financing options for associations, and it really does depend on the governing documents. Many governing documents do contain some limitations on indebtedness or limitations on the amount of a special assessment that you may adopt, depending on the purpose for the special assessment. So something you definitely need to speak to counsel to, even before you solicit offers from the lending institutions. Now, many times, or actually I would say the majority of the time, the corporation, the community association, whether it's an HOA, a condo, or a cooperative association, has all the powers and duties of a corporation under 617 Florida statutes. That's the Not-for-Profit Corporate Act. And the powers and duties of a corporation include the ability to sign contracts, incur indebtedness, pledge assets for as security for loans. So again, it just depends on how your documents are written, how contemporary they are, and whether or not you have impediments that could really make a wrinkle or make it problematic for you to obtain a loan or a line of credit. So that's something to, even if you're not looking for money right now, well, it's worth looking at this issue, because if there is some impediment in your governing documents, why not address it now? I mean, you may not need a loan until 2030, 2035, 2028, whatever it is. But if you can get rid of the obstacle now, then you won't have to address that obstacle when you really need the money. So I would encourage you, if you don't know whether or not your association has the ability to take a loan, but through board action alone, then have it checked out and make some changes to make your lives a little bit easier.
This next person has got to be a relative of yours. I'm trying to get a smile out of you, Lisa. This is Kim and Davey. I'm a board member, and I love your show. See, I knew it was a cousin of yours. All my board members listen to your show. We have townhouses, I guess condo association. Are we responsible for roof repairs? Our roof is 30 years old. Is a 30-year-old roof insurable?
Wow, I'll tell you, the insurance, you mentioned it earlier, like right at the beginning of the show. insurance is just so tumultuous right now. We've had associations with 100% increases, doubling their insurance costs, even more than 100% increases. And a lot of it depends on the maintenance and repair and the existing conditions of the building, plus the age of the roof. So that new legislation that came out addressed roof insurance and what the carriers can do, but it only applied to single family homes. It didn't apply to community associations. Let me talk about the first issue first. Is the association responsible for the roof, or are the homeowners responsible for their own roofs? Well, if it's a townhouse community that's considered an HOA, homeowners association, it's very possible that the roofs are considered part of the actual unit or part of the actual home, and therefore the responsibility of the individual owner. That doesn't happen too often where it's a connected roof that cannot be maintained solely by individual owner. In a condo, almost universally, the roof will be a common element, and then therefore the association's responsibility. But 30 years is way too long. Please take some action to get that roof repaired, maintained, or replaced. And right now there's a huge waiting time for materials with all the roofing contractors. Sure. So act early as possible, so that by the time the roof is ready for imminent failure, hopefully those materials will be in and you'll be ready to get your brand new roofs.
We have a caller from Boca Raton. Annie, good evening.
Good evening. Hi, Lisa. Thanks for all the great information. This is a little tricky, but I just wanted to understand this. Under the Marketable Record Title Act, where I live, we're in a country club. We have our own HOA, and then there's a POA. And their documents recorded in October of 1985. But then it said that they were valid for 50 years and auto-renewing for 10 years period successively. But something happened, I think, in 2018 with the amendment to the MRTA, and it turned out, so all of a sudden, it turned, the Property Owners Association said the Master Association documents were not valid. They had to revitalize them. And we'd all incurred massive fees and attorney's fees and all this stuff for that. And I'm looking at this and I'm saying, how could that be, since this was the original thing said it was, the document said they were valid for 50 years. So was there something there that triggered that made that happen, that they had to do that, and it seemed like they were no longer legal or valid or something? I don't know.
I'm sorry to hear that you had to go through this. I mean, a lot of associations are going through this, but depending on the size of the community, it really can be a very laborious project and a very expensive project that you just mentioned. But that Marketable Record Title Act, you're 100% right with the reference to the law. It's been around forever. It's basically been around since the 1960s, I believe. And it's designed to remove impediments or liens or covenants that apply to property that are so remote that nobody really knows about, nobody really cares about, to promote the marketability or promote sales, and that new owners won't have to be bound by these old covenants or these old restrictions. Unfortunately, a lot of associations got caught in the trap that they didn't know about it, they didn't think about it, and it's a 30-year time trigger. So the 30 years came and went, and nobody, thought about it twice. And now all of a sudden, the covenants are expired, and they have to go through this revitalization process. The duration of the covenants that you're talking about in the actual documents themselves, that's a little bit of a different legal issue. The reason that they're not just perpetual is because there are laws that say affirmative covenants are only valid if they're imposed for a time certain. And again, that's way beyond what you need to know as a community association leader or community association member. But everybody in an HOA or POA or other association that has covenants and restrictions where it's not a condominium or not a cooperative association needs to worry about this 30-year time frame, because I can tell you, if you take action before the 30 years is up, it's easy as pie. I mean, it's simple, easy, inexpensive and can be done. It's called a preservation of the documents under MRTA, Marketable Record Title Act. And it's very, very easy, and it's simple, and it's really painless. If you wait until after the 30 years and you're a large community, it's a lot of work. It's a lot of knocking on doors. It's a lot of letters, and depending on how complex the actual properties and how they're defined are, it can be a pretty expensive project.
And thank you so much for calling. Lisa, we got to get out of here. You did incredible. I can't wait for you to come back on the show again. Give everybody the phone number one more time.
Okay, so again, it's 954-928-0680. But I encourage you to go to www.kbrlegal.com, because there is so much resource information on there that you'll be amazed at how much you can learn by looking at the various materials that we have published.
Thanks, Lisa. And we'll be back with you again next week with more Kay Bender Rimbaum. We'll see you next week. Thanks, Lisa. Great job.
Well, thank you all. Thank you all for all the callers.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed on the preceding sponsored program were